People always say that you have to have money to make money, and that there's an extraordinary level of sacrifice on the road to success. So how is it that investors like us who didn't start out with much money and who don't rely on banks and credit, how is it that we can increase our income and build our wealth in a way that doesn't require us replacing one full-time job with another while still enjoying the things in life that matter most to us? That has always been the big question, and this podcast reveals the answers. I am Carrie Lake, and this is the Investor Warrior. Hey Warriors, we are back on TGIF. I hope you are all having a great week. I have with me Brian Bradley today. Brian, thank you so much for coming on. I'm going to let you introduce yourself to the group, but today we're going to be talking about, first of all, we can all make a lot of money in real estate, right? But we can also lose a lot of money in real estate if we don't protect ourselves as we grow our wealth. And, you know, the saying, ignorance is bliss, is not going to come into play here, because ignorance can be very, very expensive if you don't have your assets and your wealth protected. And so I brought Brian on the show because we're going to be talking about the misconceptions of protecting your assets and your wealth. So Brian, thank you so much for coming on.
Oh, no problem. Thanks, Carrie, for having me. And I love the self-intro part of it. And so this is going to be a really important topic, and I'm not anyone's legal guru. Just get that out of the way. And, we are really living in a fascinating time right now. We're seeing laws and policies that are drastically changing every day, and people getting sued and being sued that normally wouldn't be getting sued. And so protecting your assets, especially as you're trying to scale up and grow and take control of your life and your finances, is so important. So I just hope that the concepts that we're going to talk about today help you set yourself and your listeners understand this crazy maze better. And I'm definitely going to be blowing up the status quo and all the misconceptions. And so about me, so like you said, I am an asset protection attorney, and I was selected to America's Best Attorneys list in 2020, Super Lawyers Rising Star list 2021 and 2015, Lawyers of Distinction list 3 years in a row. I was nominated to the top 100 high-stake litigators list and the top 100 in real estate list. So a lot of top lists, because I just like what I do. And what we do is help protect investments and wealth with this fancy word called asset protection, which I'll break down after this intro. And I got into asset protection from just the litigation and trial side of the law, and having clients being sued and their lives just turned completely upside down with a false sense of security. And most of them just coming to me after the fact, after they're being sued. And that once you're being sued and you're coming to a person like me to protect your assets, it's too late. You're too far down the rabbit hole. It has to be done beforehand. Yeah. And so I see that what's contributing to this false sense of security comes from people thinking that they don't need to do anything. And I'm a great landlord, and I'm just going to ride Lady Luck and like Vegas rules. And that's just a bad way to gamble. It's not a plan. It's just wishful thinking, or they think that their insurance will always cover them, which it won't. It's important to have, you need it. You need to have good insurance, but it's hard to even believe just how many clients I'm coming in now with over coverage claims and damage claims that aren't being covered, or they're being underinsured and not properly leveling up their insurance as they level up and grow, or they think that an umbrella policy is just a policy that covers everything else, and it doesn't. It really just provides excess coverage. Yeah. And then the really big misconception, that we're going to break down are just the LLCs and where they actually fit in the role of asset protection. And people forget first letter, first word, limited. They tell you straight up right there. And by being in the legal system, the sad thing is it just, if you just look around, the legal system's broken. It's been broken for a while. It's not about justice any longer. We're just a sue happy nirvana. Mm-hmm. And so the legal industry has become a multi-billion-dollar just industry chasing profit lines. And so what we do is provide peace of mind for clients and then level this playing field. And we try to keep the overall goal of asset protection really is just lifestyle preservation. I can't stop you from being sued. No one's going to stop you from being sued. And as you grow more, collect more, and get more, your visibility and target increases. So you need to start thinking about protecting this legacy you're building. And so my firm, we specifically work with high-risk professionals and investors. And then within our network now, we're protecting collected about $5 billion worth of assets now.
Wow. So this is why you're on the top list.
This is why I'm on the top list. I'm just passionate. I like the law. I was a law geek. And then at the same time, I'm an investment geek and finance guy. I like taxes, not paying taxes, but, legally paying what I owe, but, using the tax code like a treasure map is the best way I've heard about describing it. And if you do it right, you can save yourself a lot of money.
Right. So here's what we're going to do, you guys. We're going to make this the most interesting, exciting conversation on law that you have ever sat through. And I'm going to reach into Brian's brain and I'm going to dumb it down for all of us.
Yeah.
Asking him the questions that you probably want to ask.
They were going to have some fun. Definitely.
Yeah. So first off, I know that this is a question that a lot of people ask themselves is, well, I'm not that big, right? I only have 1 or 2 properties. Do I really need asset protection? And the obvious answer is yes, because it doesn't matter how many assets you own, you can get sued, right?
Correct. Absolutely.
A bigger target as you get bigger.
Yeah. And I think as you're starting out, if you think about when you're going to make your most errors, is when you start out and then when you get really successful. Mm-hmm. And when you're starting out, you don't have the luxury of think of it like a boxing analogy. Not very good boxers have the ability to survive, a low punch to the floating ribs, the rib cage. You're going to get knocked down and knocked out. That's you starting out in real estate. One hiccup is going to knock you out completely. And it's going to take a lot for you to recover because you have a huge learning curve. And you're going to make a lot of errors. Deals are going to fall apart. You're not going to be, you should be spending the money on attorneys and people, but most save money on that and try to DIY the deals themselves and don't go to the attorneys until it's too late. Then they lose all their money and they're out of the game. And so that's when you're starting out, you need to realize this is probably when you're going to make your most errors until the deals get really big. You can survive stuff falling apart when you're really big. It's just going to be more expensive. So when you're starting out, this is the most important time. If you can't also add into your budget an LLC and insurance, then you're not ready to invest because that has to also go into your investment strategy of how do I protect what I got? Right. And you're going to go to your CPA. A good CPA will say, okay, what do you own it in and why is it not in an LLC? Mm-hmm. And if it's just because I don't want to spend the money, then you should not be investing in real estate yet.
Yeah. And like you said, a lot of people will say, well, I'm a good landlord. I invest safely. Give me an example. I know you were telling me an example of a doctor that you worked with. Just give me an example of something that can happen.
It's not the plan stuff that's going to wipe you out.
Right.
It's the unknown things and really big ones that are very expensive mold issues. I had, and when I was living in Michigan, we had, a big apartment complex end up dealing with a $25 million lawsuit because of mold. Or you have just your twoplex with the mold issue. And I had one where the whole family ended up getting sick from the mold and that turned into $1 million lawsuit. Those are just things that you can't really plan around. And you have insurance, but insurance, those are the cases they wiggle out. And we'll explain how and why later on. Or the one you're specifically referencing to in Jersey.
This is kind of a weird one. So I want to.
So I have there's a California resident who has property in Jersey, renting it out. Happened to be renting it out to a gang member who has having a party and turned into a gang fight. In the party, guns were pulled, a person shot and killed. Who's the person getting sued civilly for wrongful death? For negligent safety? The owner of the land. Now, great guy, doctor, saves people's lives, lives in another state, has nothing to do with this. He's the one getting sued because he's the owner. Deep pockets or not, you got to protect yourself. And so if you think about it as a pie chart, you have your assets in 3 categories. It's the I know what I know I don't know this, and I don't know what I don't know. Mm-hmm. If you know something, I don't need to ask you a question. I know the answer. If I don't know something, I could say, hey, Carrie, I know I need the answer to this. I don't know the answer. What's the answer? Mm-hmm. If I don't know what I don't know, and I have most of my assets in that category, that's where the largest area of loss is. So the 2 goals are shrink that part of the pie as much as possible, and then protect yourself for those instances coming up so you don't completely wipe yourself out.
Yeah. Okay, so let's go into LLCs and the limitations that are there with an LLC.
Yeah, absolutely. So like everyone kind of knows what an LLC is, limited liability company. If you think about asset protection, think of it as layers. It's a great way. Like if like I'm from the cold, like dressed in layers my whole life. So you wear a base layer, it's just going to sit on your skin. Then you're going to wear a second layer. This is going to be a little bit thicker, keep you warm. And then a third layer, outer shell waterproof layer, is going to keep you nice and dry and warm.
Let me put this down for the Floridians. That's a tank top, a light cardigan, and a skirt in case you go inside.
Yeah, there we go. And so
just have to remind you that we're in
the LLC tank top is going to be your foundation layer. That's your base layer. That's where we're starting out. Okay. And they're good. I use them, but the misconception is like I think a lot of people are selling them as this is your, Dracula Slayer, one size fits all silver bullet pill. And there's a lot of unspoken problems as you grow and your wealth grows that we need to understand. And the first problem, and I'm going to break them, there's going to be three. And so the first problem generally is that most clients have what's called single member LLCs, which are all in your personal name. The problem here is that the courts now have a tendency to completely disregard single member LLCs. And because of this, they're basically worthless, from a liability standpoint wise. And I see them, I use them, they're base layer protection. You're just starting out, that's fine. And what you actually want though is these single member LLCs that are not to be held in your own personal name, but to be owned by a second layer of protection called a multi-member limited partnership. And what you're doing when you're doing this is layering your protection system. Your mid layer, the limited partnership, will be owning all these LLCs as you grow. And so all those tax filings and K1s will simply passively flow directly through you to a management company. So you end up just having one tax filing, not 15. Because I have clients that come with like 15, 20 LLCs, and it's just a mess. And so we have to clean that mess up. And then what you're doing is maintaining the legal protection, but we're disregarding them for tax purposes, creating a very smooth and easy transition for fewer tax returns. And then from there, it just is a matter of mix of like, what do you own, how do you own it, and where do you go, which goes to the next big issue or problem is chasing charging order protection. And I see people having, wanting to create LLCs, and they have a lot of confusion on just like, where do I even go and set these things up in? Do you go to Delaware, Wyoming, Texas, Nevada, Florida, and you're like, okay, I heard this on the internet, or my CPA told me this, so I'm just going to go and do that. And it really comes down to an issue of just what do you own and where do you own it? And I'm going to pick on California a lot just because a lot of people live in California. It's very expensive in California, so people invest out of California. And California is a very unfriendly state for asset protection and a lot of other issues. And so,
other issues.
Yeah, and other issues. Let's just say, for example, it's California real estate that you own and you're a California resident and you set up a Wyoming LLC because somebody on the internet told you that it was better. And then you go and you hold a key piece of California real estate in it and you're paying California franchise tax on this out-of-state Wyoming LLC. Because you have to register it as doing business as in California. Mm-hmm. What you've done is just convert your Wyoming out-of-state LLC to California because you're doing business in the state of California because you're a resident of California. You registered in California, which you legally have to do. You're paying the franchise tax in California. But if you ever have a liability issue in California, the judge in California, meaning you're getting sued through that property, which is in California, mm-hmm. California law is going to apply in that lawsuit. You're not taking Wyoming or Delaware or Texas personal injuries and damages and tort laws to a state that has no connection to it. And this is because a judge in California or any other state that they don't care that your LLC is in Wyoming and registered in, a registered LLC in Wyoming. What they care is that it's doing business in California. It's done this fancy legal term called availed itself of the protections and laws of California. That's the state the asset's in. That's the state the injury's in. And the damage occurred, like I said, is going to be that state's laws that are going to be governing and applying in that lawsuit. And mm-hmm. so this is what's called outside liability that resulted from the asset, that property. It's not internal business disputes like you and me owning a business together and then suing each other. Then, yeah, you can go to Wyoming or Delaware and get some benefit. And there's reasons why you can consider doing that. But real estate is different. real estate, you're not operating a business through that LLC. It's a holding company, which is an extension of you. So just by simply owning an out-of-state LLC, you like I said, you have to register it and doing business of in that state. You've now done that fancy legal word, availed yourself of the privileges and laws of that state. And a very good case on this is Indian Palms County Country Club Association versus Anchor Bank in 2015. It lays out every legal standard that you have to have regarding jurisdiction and using out-of-state LLCs and piercing the corporate veil. And if one of those standards are missing, you automatically lose. And then from there, you're just piercing the veil. And then the last big issue I see in confusion is this fancy word called anonymity, And this is where I think people think that they can just create an anonymous Wyoming LLC and completely disappear and ghost a lawsuit. And that's just completely false. And it's not how the legal system works. And I get these questions probably 2 or 3 times a day. When your LLC is sued, you're going to be legally required to appear and defend it. Like you have what's called a personal agent of service in Wyoming, which you legally have to have it legitimized. Their sole job is to say, hey, Carrie, guess what? You just got sued. You're served. Now go get a lawyer and defend yourself. Once that happens, you legally are going to have to go into court, and the judge, through the legal discovery process, is going to say, here's the asset disclosure list. You're being sued. We have to make sure you're collecting like what you have to collect on. At that point, you have 2 choices. You either lie and say you own nothing and your LLCs own nothing and commit perjury and go to jail,
right?
Or you disclose your assets. So the anonymity is out the door. What anonymity actually does is a privacy protection from being harassed as a business owner. But it doesn't mean that you're just going to ghost and avoid all lawsuits that you go through. You're still going to have to go get a lawyer and defend yourself and potentially lose your assets.
Right. So going back to the LLC, the multi-member, and the difference between single versus multi, how easy is it to establish a multi-member LLC? Let's just say it's just me. I'm the business owner.
Yeah. You can add, you can add another member. It could be like a family member, and it just makes it a little bit harder to tie up the assets. You're not going to get any additional protection because it's still the same protection, the same arguments, piercing the corporate veil arguments. But what it does is it allow you not to affect the ownership of another person's assets, ownership assets that aren't involved in a lawsuit. So it helps a little bit. I still prefer. I prefer a multi-member LLC over a single-member LLC.
Right.
I prefer a limited partnership over an LLC, which we can break down, whenever you want to do that, because there's a big distinction between the two and when you use them.
Okay, let's break it down now. What is the distinction between an LLC and a limited partnership?
Yeah. So they're like LLCs. And they also have some charging order protection, meaning you can go to different states, to set them up in. And some states have stronger protection orders for the member owners or partner owners, like Wyoming, Delaware, Arizona. And I like them better because they have a very distinct delineation between the managing partner, called the general partner, and the minority partner who does not. So think of it having like a dual split personality. Is like the best way to envision in your mind the distinction. An LLC has one mindset. Limited partnership has a crazy dual split personality. And we like having both a general partner interest and a limited partner interest. And we use the limited partner as the starting point for clients for that second layer protection, that holding company. And then we add a bridge trust or an asset protection trust to it for the actual asset protection component, the very strong component of it. And it's really the combination of those two working together that you want to capitalize on. And so just for like specifics, some of the specific reasons I prefer, and I specifically prefer an Arizona limited partnership over a Wyoming LLC and others, is that you have exclusive charging order protection in Arizona as the only remedy for creditors. So, and it's exclusive. You have an actual statutory distinction between general partners and limited partners. This is by statute. And so this is better than LLCs because LLCs can only do this or accomplish it by an operating agreement. And then when you get sued, those operating agreements, depending on the state, are left up for court interpretation. So I'd rather have a statute define that than a court and a judge.
Right.
Yeah. And then Arizona has AR section 29-333, which specifically allows for the limited partner to make what's called a unilateral withdrawal from the limited partner on what is a predefined event of duress, like a lawsuit. So it's predetermined. Lawsuits were allowed to disconnect the limited partnership from the asset protection trust. This is very unique only to Arizona, surprisingly, and this can't be done with LLCs. And if you can try to do it with an LLC, you then open yourself up to what's called a claim of prohibited transfers. And those are just a few of the benefits. And a couple other good ones are the Arizona limited partnership is perpetual, whereas LLCs aren't. You have to renew them and pay annual reports and filing fees every year.
Right.
Arizona doesn't require listing the limited partners, so you only need to list the general partner. So by nature, limited partners are completely private by statute. And then another big one is for like tax filing purposes. Your limited partnership can't be a disregarded entity, just by the nature of a limited partnership. But LLCs, if you just have one member, they're automatically considered disregarded entities, which might be good for taxes. But when it comes to liability and lawsuits, it's horrible.
Can you explain what a disregarded entity is?
It's just where you're going to end up becoming personally liable for a lawsuit, or like you're the managing member. It's disregarded tax-wise, taxes pass through you. You don't want that from a lawsuit standpoint, because if it's a disregarded entity, meaning like there's no corporate bail protection, really is the best way to break it down. You, the member, are now responsible and all your assets are at risk.
Personally.
Yeah, personally, exactly. And so it's great for taxes. That's why when you go and talk to your tax guy, make sure afterwards you go and talk to a lawyer and an asset protection lawyer, because the two you need to maximize your tax mitigation, but at the same time not open yourself up to a really bad lawsuit and lose everything, because then your CPA and your wealth managers have nothing to work their magic on. Yeah. So you got to balance them both out. And so really you just have so many additional protections and mechanisms statutorily that are put into limited partnerships, that at that mid-layer protection, that I like them. But I still use LLCs at the foundational base level.
Yeah. So let's go back to what we were talking about with anonymity. I was telling you that we put all of our properties in land trusts here in Florida.
Yeah.
And land trusts are a great vehicle for holding real estate, I think, in Florida. I mean, that's how Disney bought up all the land down here in Orlando, was he bought these different parcels of land in land trusts, so no one knew exactly who was buying them. They didn't really know one guy, right? So there is a little bit of a factor there when it comes to anonymity. What's the difference between, so I put my house into a land trust with my MultiMember LLC being a beneficiary, and so I've got a couple of layers of protection. How do you do it differently?
Yeah, so we really don't use land trust, but I'll just break down because at a base level, that could be a great way. Like you're just starting out, LLC land trust. As you're going, like most of my clients come to me with, millions of dollars of real estate, lots of LLCs. We're using a different type of trust. We're using an asset protection trust. So we don't need the land trust. But just so your listeners understand, what you're talking about and why you're doing it. So a land trust is like any other trust, but they just hold land. That's it. They're essentially, like you mentioned, a privacy device. And that's the big distinction. It's just a privacy device, and it's not an actual protection device.
Okay.
And that's because under the land trust agreement, your identity as the legal owner can't be disclosed. And that's like with all trust. And so it can't be disclosed to the public unless it's ordered by the court. All they're going to see is the name of the trust, not yours, like 123 Main Street Trust.
Right.
So you transfer your property out of your personal name and into like 123 Main Street Land Trust. But the issue here is that the land trust, they don't have built-in asset protection or limited liability. They just separate ownership from use of the land and then help transfer assets without potentially invoking a due on sale clause, which, unless you're paying your mortgage, we haven't been able over 30 years to find a case where a bank literally called a mortgage due simply because you transferred an asset from your personal name into your LLC that you're the managing member of. But if you're just using a land trust and you put the asset simply into a land trust, there's no built-in protection mechanism. So if you get sued, the beneficiary, meaning you, still can be liable, sued, and collected on it. So you would have to connect it for protection to an LLC. and you're only going to get the protection up to the amount of piercing a corporate veil for an LLC. Okay. And so as you level up, just realize that's a good starting point. It's going to combine a little bit of protection with privacy. And then as you scale up and grow, you're going to be moving your protection systems to fit your level of liability.
Mm-hmm. Okay, so that is the distinction. It's privacy versus protection.
Correct. And then it has to be connected to an LLC for some protection components. And then as you scale and grow, so does your protection needs.
Okay, so now talk to me about like the warmest layers, okay? Like how can we get the warmest, the biggest amount of protection with these different layers?
Yeah, absolutely. So, you know, we had our base layer, our, what is it, Carnegie that you said, or?
Tank top.
Tank top. Yeah, your tank top.
Coat because it rains a lot here in Florida, and you always got to bring a sweatshirt because they blast the ACs everywhere you go. So it's always
so you got your tank top.
Degrees to 60 pretty quick.
Yeah, you got your tank top, which is your LLC, and your real estate's in that LLC, and risky assets that need insurance, need a key, can go boom and hurt somebody or kill somebody. Those go into your tank top. Then you have your sweater, your second layer, which is your limited partnership. Now your third layer, you're really strong outdoor bad weather, you know, like we're hanging out in Siberia.
Yeah, it's getting bad.
Yeah, it's getting bad. You're really growing. You know, some things can happen and you don't want to lose stuff. That's an asset protection trust. And I want to break down asset protection trust through a discussion of jurisdiction because it'll make more sense. Mm-hmm. And so this is where creating an asset protection trust and more importantly, picking the proper jurisdiction is really going to come into play. And trusts come in lots of different flavors and types. Like we mentioned, there's land trusts, revocable living trusts, which are not asset protection trusts. They're just estate plans. Then there's domestic asset protection trust, offshore asset protection trust, charitable trust, lots of different type of trusts. The standard 101 trust that everybody is going to be familiar with from the 60s is the family revocable living trust. You know, trusts don't die. So when you do, you actually fund and you funded them properly, meaning transfer the assets from your name into that trust. It helps with avoiding probate and courts and making sure your assets go where they're supposed to go. It changed the landscaping of estate planning. Mm-hmm. Then you also have land trusts, which we discussed. And then from there, we have a higher level of trust protection called asset protection trust. And these really came into about in the early 1980s. And what these really are called, the fancy word, self-settled spendthrift trusts, meaning they're created by you for yourself as your own beneficiary with some kind of creditor protection from spendthrift provisions in there. This lets you protect your assets while you're living from creditors and not having to relinquish control of it. The difference is they allow you to protect your assets, not just for your grandkids, but for yourself, you know, which wasn't allowed in the past. Now, the difference with an asset protection trust really comes down to where you just set them up at. And why this is so important is that the laws and the rules that govern you and trusts and business entities, and, you know, they're different from one jurisdiction to another, meaning one state to another, one country to another, even one county from another. Mm-hmm. So you really have three options, like I mentioned. You create them here domestically in the US, you can go offshore to another country like the Cook Islands, or you can create a hybrid, which is a combination of both of them. Mm-hmm. For the historical context of this, the offshore trust came first in 1984 in the famous Cook Islands. It was, you know, they created the asset protection trust. I personally prefer the power of going offshore if and when it's needed for a client, just because it offers the best home court advantage. And that advantage is this fancy word called statutory non-recognition. And that's what makes it the global standard still for over 40 years. And what this means is like a US judgment is completely worthless in the Cook Islands. They would have to sue you there, prove their case by the murder standard, which is beyond a reasonable doubt. You know, the plaintiff would have to front all the court costs and fly in a judge from New Zealand. You can't take your US attorneys with you there. They don't take contingency fee-based attorneys there. And if you lose, you pay, which is a huge feature because we don't have that in the US. So that invites a lot of predatory lawsuits. And then there's only a 1-year statute of limitations. But the downfall, because everything has pros and cons. Even with all that strength, the downfall is like, it's very expensive for a purely foreign trust. And not everybody needs to be purely foreign. It's generally overkill for, you know, 9 out of 10 people. And honestly, it's just like I said, a hard pill to swallow, because then you're going to have high cost, high maintenance cost, and then you're going to have a lot of IRS hurdles that you're going to have to jump through with additional IRS filings and disclosures of assets. And most people don't want to deal with all of that. So then they go domestically and they look domestically. The domestic asset protection trust came 10 years after the Cook Islands started. And in all places, it started in Alaska. And then, once someone does it, then you're going to have like Wyoming and Delaware and Nevada. They're going to jump in and follow suit. And now we have about 20 states with some sort of domestic asset protection statutes and legislation. But the problem with purely domestic asset protection trusts and why they fail on effectiveness, which is what you want, is the U.S. Constitution, the full faith and credit clause. You can't run from lawsuits in the U.S., and not all states recognize asset protection trusts. So if you're a California resident and you have a Nevada asset protection trust because California doesn't have the statutes, there's a case, Kilker versus Steelman, 2012, that came out and said, hey, you're a California resident. You're not a resident of Nevada. We don't care that you have a Nevada asset protection trust, so that's not going to do you any good in a California lawsuit. We're piercing it, and we're getting into all those assets. That's why I prefer what's called a bridge trust. It's a hybrid of a domestic and a fully foreign asset protection trust. And what you're doing is just combining the best of both. It's a fully registered foreign Cook Island trust from day one, from the moment you created it. But we build a bridge back so that the IRS classifies the trust as a domestic US-based trust. And so because of that bridge, it makes it cheaper to start, especially, like when you're getting to that 1 million net worth of unprotected assets, it's worth this level of protection. It's then more flexible. You don't have any of the annoying IRS compliances and really no IRS tax filings and disclosures at all, because the trust is classified domestically as a US grantor's trust. But then you get that power of the offshore component of statutory non-recognition in your back pocket or your toolbox when you need it. And if you ever need it, we just drop domestic compliance by removing you as the main trustee. It automatically shatters compliance with USC section 7701, and now you're purely foreign.
By the way, guys, we have a flow chart that Brian has provided for me, because I know I'm a visual person, and this will kind of help break it down on how this trust operates and works. I think you answered my question, but my question was going to be, at what point do you see clients going towards the bridge trust? At what point in their financial journey? Great
question. So all of this is scalable, and where you start is not where you're going to end. So if you're just starting out, I would say you start out with an LLC and insurance, and get as much insurance coverage as you can, even consider an umbrella policy. Just know the limits, know what your coverage is. And then as you grow, let's say you start having 2 or 3 LLCs, like 3 or 4 assets spread across, you come in around 250, probably 500,000 net worth. That's when you come to the management company. Then when you get to about 850,000 to 1.2 million of unprotected net. So this isn't your 401ks and your IRAs, because those are exemption protected. This is unprotected assets. That's when we start talking about asset protection trust. And then generally we go towards a bridge trust when you have 1 million plus unprotected assets.
Okay. So I have some questions about the bridge trust. Do I have to do non-recourse loans inside of the bridge trust?
You can do any type of investing in loans that you want, because it's a grantor's trust. Okay. So there's no limitations to that. I know when you're using like a domestic irrevocable asset protection trust, those generally aren't grantor's trusts, so there are limitations when you go to banks and get lenders. That's why we use grantor's trusts. They're easier to use. Banks like them. Lenders are comfortable with them. And then if it ever has to go purely foreign, it's still just a foreign grantor's trust.
Okay, got it. I had one other question. I should have wrote it down, but I was following your explanation of the bridge trust, and it was, it's going to come back to me. All right. What are the costs associated with creating these trusts?
Different types of trust, a bridge trust with an asset management limited partnership would be $29,000. The trust itself, you'd be plus or minus $23,000, because you have both a foreign and domestic trust. Limited partnerships, you see firms like on average like $6,000 for the limited partnership. Different charitable trusts, depending on, that's not really an asset protection plan, the way asset protection works with charitable trust is you're taking the money and gifting it out of your name to like donate or gift it to somebody. Those would generally be around like $8,000. So it depends, but on average, like what we charge for a bridge trust setup, like a full package would be 29.
Okay. I do remember my question now. Legacy planning. How does the trust operate when I pass away?
Yeah. So generally the trust, if you're married, is going to be you and your spouse. And then it'll also be you and your spouse as the managing members of the limited partnership. And the way succession planning would be there is if you start having kids and they're older and, you want to, have your kids take over the real estate, you just add them as managing members to the limited partnership. And then the trust, whoever the spouse passes, that you're still the trustee created for you on the bridge trust. And then once you finally pass, then the assets would get distributed per your directions of your living trust.
Got it. What about when we go into partnerships, right? I have a business partner and we purchase a property together. How does it work there?
Yeah, so you would just, the asset, you would put into an LLC that you and your partner would create, and then you would have your operating agreements. You would have a percentage of ownership of that. You take your percentage of ownership, put it in the management company.
Okay.
And then same thing like syndications. If you invest in syndications, if you're passively investing into them, those passive syndication shares go directly into the management company. Because it's not risky. There's no risk asset there. You just want them out of your name so someone can't collect on that asset from you. If it's passive, whatever is passive, like even your personal brokerage account, out of your personal name in a management company. If it's risky, it needs, like I said, insurance, key, it can go boom, it can hurt somebody. It's going to go into its own, LLC. Then that ownership share, whatever it is of yours, goes then into your management company.
Yeah. Okay. So we heard a story about what happens when you're not protected. Can you give us an example of a story of something that happened where they were protected?
Oh yeah.
Not all doom and gloom here, you guys.
Not all doom and gloom. So we have like a lot of them. Like I have our good medical doctor ones, because they make a lot of money. Like I have a lot of surgeons who invest in real estate, and so we got a medical doctor who was investing in real estate, and he had a $3 million malpractice lawsuit, and that resulted from a surgical error. And most doctors only carry $1 million in malpractice insurance. So it's $2 million, $2 million over the $1 million insurance coverage. And really when it comes to lawsuits, like I said, like insurance just provides capital to fight the lawsuit. But that case settled below the 1 million mark, and it was forced to settle before that because it was uncollectible on the overage coverage. So that was a win. A $34 million malpractice suit, so another doctor that settled for under 1 million. $75 million personal loan suit where you're personally guaranteeing to pay back $75 million, and that settled for $5 million with payments spaced out over years. So what forces these to settle in your favor or for pennies on the dollar in a lot of them is how is your protection system perceived to be effective or not?
Well, how is it, right? How easy is it for the other?
Like if it's LLC, is like I'll gamble and pierce that in a heartbeat. Like I'm not scared. No one's going to scare me away with an LLC. But if you start using offshore Cook Island Asset Protection Trust with 40 years of case law all the way up through the Supreme Court, like the Anderson case, the Slow case, all these Supreme Court cases, and just all the case law you see of offshore trusts that are successful, you have decades of them, all come from the Cook Islands. And so we're very upfront when we get brought into a lawsuit, and we're not just hiding assets. We just say, hey, yeah, you're right. We own that. You're absolutely right. And we also have a bridge trust, which has an offshore component to it. If you don't go away, the equity and the assets are going to, we're going to trigger the migration clause, and the assets will go and trigger over there, and you'll never receive a penny. At that point, you're not collectible. Here's the case law. An attorney is going to review that and say, am I going to front this much money to lose a case or win a case and not receive any payment and collection off of it, settle for pennies on the dollar? They're going to go broke. So at that point, they're making a business decision. That's when lawsuits just walk away.
Yeah. Yeah. So that way you don't see yourself up on the billboard that the other person got all this money from you.
Exactly.
I hate those billboards. I'm not going to name the lawyer who does the billboards, but they really bother me. So-and-so got me so much.
Yeah. And that was like, prove it. I can't
really have a problem with those.
Yeah.
Okay. So just as a recap, let's just recap all of this. So for
Yeah.
someone starting out, what's the best way to protect their assets when they have a couple of houses in their portfolio?
Yeah. So you're just starting out, LLCs, insurance. And if you feel like you want to go with the land trust for some privacy, throw in the land trust.
Okay.
Next level up, then you're going to go into the asset management limited partnership. Start having those LLCs flow into that. That way you only have one tax filing. You have your accounting system and your ledgers into that management company, one bank account. That management company starts doing all the business, not you personally. So it has a nice second layer of protection. Third layer, then you come in with an asset protection trust. And then where we set that up in depends on your profile, your net worth, what you have, your risks. Like, are you a doctor who also owns real estate? Are you like you, Carrie, like big time real estate invest? It just depends on the person at that point of where and what we set up. I would say be cautious of anyone that you're talking to who's saying one size fits all. Just do, series LLCs were a big topic. The problem with you fall into that trap, not every state recognizes series LLCs. So unless you live in a state that has them, recognize them on statute and your assets in the state, and you get sued and you're not in a series LLC friendly state, is worthless.
Yeah. I think it's the same thing with land trusts. Not every state recognizes land trusts.
Exactly. And so you got to realize in big lawsuits, eventually the safest place is to eventually have some sort of offshore connection when it financially makes sense. If you're calling me and you're just starting out and you wanted to set up a bridge trust, I would tell you no, and I wouldn't take your money because it makes no financial sense at that point. Right. I will hope you get there and I'll set you up with the people to help you along that path. But it has to be marketable, manageable, scalable, cost efficient and effective.
Mm-hmm. And then is there a annual fee to keep that trust going?
Yeah. So like all offshore trusts have a fee. Like if you're purely foreign, meaning just a purely foreign straight, Cook Islands trust, generally you'll see those around $5,000 to $10,000 to maintain. A trust is around $2,100 to maintain annually. And then, limited partnerships, generally around $600 to maintain. LLCs are about $100, depending on the state, like I say, like average $100 to maintain.
Yep. And what is your suggestion for someone starting out who wants to form an LLC? Where's the best place to do that?
I would say talk to a lawyer, but if you don't really have much money to have them set it up for you, then I would say go to Bloomberg. We outsource some work when we get really bogged down to them, and they do good work, and that we don't have to fix. If you do it on yourself, eventually it's just going to be a junk LLC, and we'll have to fix it.
I know, because we did.
Yeah.
We created our own LLC.
Yeah.
I think at one point our CPA was like, we got to fix this.
Yeah. So that's why I say, if you want to spend money 2 or 3 times, do things yourself. If you want it done right and cheaper over the long haul, hire a professional.
Yeah. And I know there's a lot of resources out there like Rocket Lawyer and Legal Shield, and that will set you up with an LLC that is probably fine for now, but that you'll probably need to tweak.
Yeah. When you get into those second and third layers, the limited partnerships, and definitely when you start dealing with asset protection trusts, you do not do those on your own. Go to an asset protection specific specialist, because there's specific language and specific ways that have to be created and connected.
Yeah. All right, you guys. This was a lot. So I would like to know, Brian, where people can connect with you or contact you if they have any questions.
Yeah, absolutely. You can jump on my website, www.btblegal.com. I have it more as an educational resource page with a lot of case law, frequently asked questions, educational videos, because I'd rather people just get educated before they go shopping around. It's like going into a doctor. You get a lot of stuff thrown at you and it just blows your mind up. So you need to be able to have a resource to ask educated questions and know when you're just being sold a bag of goods or not. You can email me, Brian, BRIAN at btblegal.com. I'm answering people's questions. I do one free consultation, for people. I'd rather just have you educated, whether you come with me or not, just like I said, so you have a better decision-making process.
Yeah. Don't call Brian after you get sued.
I get those a lot. You're too far down the rabbit hole. What we have to do is exempt that lawsuit and then protect you for future lawsuits.
Right. It's always good to set this up from the beginning.
It's like wine. Yeah, it ages and gets better and stronger.
And I'll say too, it's never too late to set it up also.
Yeah, no, like most of my clients come with, you know, tons of property in their name over the last like 15 years, just sitting there. And then they realize, oh my God, like normally it's a friend that got sued and scared them.
Yeah.
And then they're like, oh, I can't go through that. And then they make a phone call.
Yeah. All right. Well, this was the most interesting law conversation I've had in a while. I learned a lot. So thank you so much, Brian, for coming on here and just sharing all this information. And
absolutely.
Again, you guys, if you have any questions, you can contact Brian. All of this also is going to be in the show notes. So if you want to go back and take a look at the different things that we talked about, it'll be in the show notes for you. So thanks, Brian.
Yeah, thank you.
All right, you guys, remember you are only one deal away. Take care, and I will see you on the next